is lack of reasonable and probable grounds still a defense for an impaired driving in an over 80 case? Well, this is an interesting issue. I did a video on this a number of years ago, and this was a very legitimate defense where we regularly won cases on. And let me give you an example of how the defense worked, and in theory could still work, but I'll explain how it's become more limited. So the police see you swerving and maybe have an odor of alcohol on your breath. A swerve, a slight swerve, and an odor of alcohol. That's it, and one swerve. Now they have to make a decision. Do I have reasonable grounds, that's reasonable and probable grounds, to arrest that person for impaired driving? In other words, do I really have grounds that they're impaired just based on an odor of alcohol and one swerve? Or should I give them a screening test because I don't have those reasonable grounds? I would argue in that case, there's an argument that they should maybe give them a screening test because that is sort of on the edge that they may not have proper grounds. Now, back in the old days, if I might put it this way, we brought a Section 8 search and seizure argument under the Charter and a Section 9 unlawful detention that they didn't have proper grounds with a view to excluding that evidence, excluding the breath sample and any statements they made under Section 24.2 of the Charter. 24.2 says, the breach has brought the administration of justice into disrepute, and there was all sorts of tests on how to exclude it. So that was a real good defense. We won a lot of cases with that because the police sometimes overstep their boundaries. They'd arrest someone when they didn't really have grounds. They just had an odor of alcohol, maybe one other minor symptom, but it was just slight. By the way, if you have a bit of concerted bad driving and a slur and an odor of alcohol, that's probably reasonable grounds. I mean, I don't want to make a rule of thumb, but when you have, more than say, when you have at least 3 symptoms, it's probably reasonable grounds. That's a bit of a rule of thumb, although I don't want to say that. But slurring and a bad driving clearly is. A motor vehicle accident and an odor of alcohol could be. So we won a lot of cases like that. So what happened in recent years, the Supreme Court of Canada came out, and Ontario Court of Appeal, and they really limited that defense because under 24.2 of the Charter, there's certain tests that have to be applied to whether administration of justice brought in disrepute. And the court essentially said they really limited the defense. It's hard to win it now because it has to be a very egregious breach. One of our lawyers recently won a case, which was a really interesting case on this very point, where it was an egregious breach. The court found that the officer really, to use the vernacular, screwed up and breached their rights. But just in a standard, the officer made a bad judgment call, but they were doing honestly, you're probably not going to win an RPG argument anymore, a reasonable probable ground argument. I have one in another case, which is very interesting, where, not to get into it, but the officer really screwed up. I think I'm going to be able to establish the breach in that case, but it's been really narrowed now, so it's going to be harder to bring. Now, on the other hand, if you've got a refusal case, the interesting thing about if you refuse to provide a breath sample, by the way, you should tend to always provide the breath sample. I'm never telling someone to refuse. But if the officer lacked reasonable and probable grounds to arrest someone for impaired driving, and they ultimately refused the breath sample, you have an absolute right to refuse if the officer didn't have reasonable and probable grounds. So the case gets thrown out. So that defense is still valid. I have a video on that. So the message I'm giving you, unfortunately, I'm a bit of the bearer of bad news if you're charged with a DUI, is the reasonable and probable grounds Section 8 Charter application and Section 9 unlawful detention application, where you're arguing lack of reasonable and probable grounds to throw out your breath samples. That's become a much more difficult, not impossible, but much more difficult type of application to bring. And it used to be kind of liquid gold. We won those things for years, but a lot of commentators think it's a good thing, and I won't comment either way. DUI, people drinking and driving is not a good thing, obviously. So let's face it. But that's it in a nutshell about what's going on with reasonable and probable grounds defense under the Charter in Canada. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.